I don't want to talk much about that yet. This is the state constitution, so-called. It has 37 missing parts at federation. It is not the constitution that it should be. There's an Imperial Act and Letters Patent put in the Constitution of the State of Western Australia in 1900, issued by Queen Victoria. Now that has the extra 31 sections that are missing out of this. But Mr. John Forrest decided he would remove all the sections that affected his government. But he come unstuck because this is the proper constitution. It is not junk, it is easy to understand. I mean, I say that because I've been in law a long time, but the fact of the matter is it's written so you can understand it. This is backed up by the common law. And I'm not religious, this is the common law. The King James Version of the Bible was put in place in 1614 with the Imperial Act and Letters Patent as the common law of the people. The only reason I've got this now is because if you want to understand this, the quickest way to understand it is to read this. You don't have to be religious. You read this, you understand this, which is very easy. This is dead set simple. Because like this, we are totally free. What that means, if you drive or walk down the street, you are not subject to any single law unless you break one. And then you are subject to that law and that law only. You cannot be held accountable. Like, the police cannot pull you over for a random breath test. There is no such lawful thing as a random breath test. They are depriving you of your liberty. Then they poke something in your face and say, blow in this because you're drunk and prove you're sober. That's exactly what they're saying. If you want proof of that, refuse to take it. They lock you up for being drunk. So what are they saying? You're drunk. Now to get off the police, because they're not very nice people, even though I was one, look at your local government. Local Government Act was added to the state constitution with number 88 in 1979. It's an act of the State Parliament of Western Australia. It was done without a referendum, and a referendum is required under section 123 of the Federal Constitution. It states to increase or decrease the authority of the Parliament of a state. It requires a referendum in that state. For the state to set up a local government in the way that they did, they've increased their power because they've taken possession and authority over your land. In 1988, when we had a referendum, the people voted no. In every state in Australia, 66.42% of Australians voted no to local government. No to the establishment of local government, no to the continuance of local government, no to the empowering of local government, and no to local government making bylaws. They were the four sections of the referendum. The referendum was to add section 119A to the Federal Constitution. In Western Australia, 70.24% of the people said no, we do not want local government. But Bob Hawke, in his wisdom, decided we were having it anyway, so they put it in place. Now, what local government, according to them, has, under their act, they own your property. You can't build a house on it, you can't put a fence up, you can't clear it, you can't do anything on it without a permit from them. So they say. I went to see them about 8 years ago when I bought my property, and I wanted to build a 10 metre wide, 15 metre long, 5 metre high shed and build a double-storey house inside it with a balcony either end and a veranda each side. I put in the plans, being a good little citizen, not. And I was going to pay them some money. I said, no, I'll see what you're going to do and then see what happens. So next I got the plans back and they said, you can build your house, your shed, but you can't have verandas, you can't, it has to be 4.5 metres high, you can't live in it, and you can't have any balconies back in front. And you must put a caveat on your property to say that you will remove the shed if you subdivide it. So I said, well, you've approved the shed. He said, yes, on those conditions. I said, well, I own the property, you don't. They said, well, you can't build a shed. I said, well, I'm going to anyway, and I did. And I built it 5 metres high, and I built the verandas and the balconies and everything else, and we built it out as a house, my wife and I. Next thing, we got a summons to go to court because we told them we're not paying their rates, they can shove them. They're their rates, not ours. And the magistrate's court is a joke. You go in there, the magistrate says, oh, well, the government passed the act, you have to pay it. And that's all there is to it. And I said, well, I'm not going to take that, so I went to the district court, and then we ended up in the Supreme Court before a single judge, and Mr McKechnie, and he's a peanut, and he said, no, they don't have a case, so we'll throw it out. I went before the full bench of the Supreme Court, and then Christine Wheeler, Paulin and Buzz, the 3 judges, ruled that rates are a tax and can be collected by a public authority for a public purpose. And that's an eye-opener, because when you set up the local government and you read their act, under 2.5 of their act, they have to be set up as a body corporate. Subsection 3 of that section states they must be done as a natural person. Now, the councils in Western Australia are not set up as corporations, they're set up as companies. They have an ABN, they don't have an ACN. They send out a tax invoice, rate notice. If you read your rate notice, that's exactly what it says. But that's where they come unstuck. Number one, their act says they have to be a body corporate. Now, if you remember what I said about the referendum, the referendum denied them the authority to exist at all. Now, Wheeler and Pullen and Buzz ruled that the referendum was at federal level and didn't affect state legislation at all. It was a load of crap, but you don't argue with them, you just go back and go around and fix them up a different way. So I went back to court again, and I said, they're a body corporate, trading as a company, they're not registered with ASIC, so they're committing a fraud under section 53, subsection 4 of the Trade Practices Act, because they're trading as a corporation while not duly registered. Now they said, well, we don't have to register. Well, section 5 of the Federal Corporations Act of 2001 says they do. At least municipalities and all government departments must register with ASIC. And they said, oh, well, we're not subject to that. Well, 109 of the Constitution overrides any state law that interferes with the federal law. So they do. So the paper I sent around to a few people so they could understand it, your councils are trading as companies. They should be trading as a corporation. They claim to be a corporation, but to trade as a corporation they must register with ASIC. Now the problem with registering with ASIC, they move into federal legislative authority. Under section 51, subsection 20 of the Constitution, it says companies formed under state legislation, once formed, come under federal legislative authority. That's why they're in section 5 of the Federal Corporations Act of 2001. They must register, and they're not. So the first problem they got, they're all committing fraud on you and everybody else because they're trading as a corporation. The second problem they have is they have no authority over your land unless you grant it to them. Because all your land, if you look at your title deeds, it states this is an estate in fee simple. Fee simple alienates your land from the Crown. Because it is a contract between yourself and the reigning monarch in ownership of that land. And it says the only thing the Crown has access to is the minerals that are under your land. They do not have access to your land. So the government can't tax your land. Now, they claim they can, so we went back and had another argument with the Attorney General, and we discovered that in section 51 of the Constitution, once the federal government taxes a certain area, being the land, and they started taxing it in 1910, right through to 1953. Then they decided they didn't want to tax it anymore. But because they took up that tax avenue, it barred the states automatically from ever taxing land. under section 52 of the Constitution. It bars